Well, good morning. Yesterday we finished up with a look at the mechanisms by which black people lost the right to vote in the South during the post-Reconstruction era. And I meant to mention on yesterday that, in the last lecture, that in fact, as a result of these kind of mechanisms, black people were effectively disenfranchised in every former Confederate state between the years 1890 and 1910. So almost 20 years, black people throughout these southern states basically lost their right to vote. And that right to vote would not be recovered until 1965. With the passage of the Voting Rights Act, but we'll get to that in due time. What I wanted to talk about this morning was the mechanisms by which legal forms of Jim Crow segregation were put in place. To put legal forms of segregation in place, the white South had to overcome the Civil War amendments, the 13th Amendment, which abolished slavery, the 14th Amendment, which defined the rights of national citizenship. So again, remember, the 14th Amendment said if you're born in the United States, you're a citizen of the United States. If you're a citizen of the United States, your rights cannot be taken away from you without due process of law. And certainly your rights can't be taken away from you on the basis of the color of your skin. And so how is it that the South is going to impose a discriminatory legislation in the presence of the 14th Amendment, which would be more than likely violated by such laws? And then finally, the 15th Amendment, extending the right to vote to black men. And we've already seen how that was gotten around. It was gotten around not by legislatively banning black people from voting, but by looking at the actual situation of black people and defining legislation that excluded a poor, illiterate population. The 14th Amendment, again, this is the amendment that has to be gotten around. It says this. These are the words of the first section of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So if you remember, one of the first pieces of legislation that the Reconstruction Congress put forward was the Civil Rights Act of 1866. And this 14th Amendment was drawn up, among other reasons, to defend and protect and serve as the legal bulwark of this Civil Rights Act of 1866. Civil Rights Act of 1866 basically said this, that you cannot deny a person access to public accommodations, public amusements, public transportation, public lodgings, without due process of law. That's what the Civil Rights Act of 1866 said. That law came before the Supreme Court in the year 1883 in the case known as the Civil Rights Cases of 1883. And what the Civil Rights Cases of 1883 1883 did was they overturned the constitutionality of the Civil Rights Acts of 1866 and 1875. Let's go back and look once again at this 14th Amendment. And I want to call your special attention to this line here. No state shall make or enforce any law which abridges the privileges or immunities, nor shall any state deprive any person of life, liberty, or property. And so the way the 14th Amendment is written doesn't say, and this is the argument of the white South in front of the Supreme Court, the 14th Amendment does not say that I, as a private restaurant owner, don't have the right to deprive you of the access to my restaurant. In fact, the white South makes this claim, that in insisting, in the Civil Rights Act of 1866, insisting that I, as a restaurant owner, must serve you as a black person against my faith and against my beliefs and against everything I stand for. I have to serve you. In fact, the state, the federal government in this case, has deprived me of the use of my property. The use of my property is I can do with it as I please. And if I choose not to serve you food in this establishment, that's my right. And my 14th Amendment right has been violated by the federal government's insisting that I serve you when I don't want to. And the Supreme Court, with one single exception, agreed to that interpretation of the 14th Amendment. The 14th Amendment, an amendment which was designed to protect the rights of black people, turns into an amendment that deprives them of their right and gives the right of white establishment owners, gives them the right to discriminate in their establishments. The counter-argument, and I would add this, the counter-argument is this, and one justice on the Supreme Court, John Marshall Harlan, argued in this way. There can't be any pretense, he said, that a public accommodation or a public transportation, a restaurant, or a trolley line is independent of the state, that the taxes that build the road are the taxes of all people, and the restaurant would not exist and could not exist absent the action of the state. And so therefore, if the restaurant benefits from the actions of the state, then it is similarly responsible to the state. Moreover, a restaurant is regulated by the state in its comings and goings. And so, quite apart from the spirit of the law, Justice John Marshall Harlan says, even in its wording, this is a violation of the spirit of the law and the wording of the law. There was one difficulty as far as the white South was concerned in terms of imposing legal forms of segregation. And that is that still the civil rights cases of 1883 still imposed a ban on the state. The rationale behind the ruling in the civil rights case of 1883 imposed a ban on what the state could do in terms of legislating discrimination. And so for 13 years, although private businesses might successfully discriminate against black people, the state itself, the state of Louisiana, the state of Georgia, the state of Alabama, the state of Mississippi, could not pass legislation that was discriminatory, that justified the segregation of the peoples in the state, the races. That problem was overcome in the Plessy versus Ferguson decision of 1896, one of the most famous, notorious decisions of the Supreme Court. The case of Plessy is this. Plessy was an extremely light-skinned black man in Louisiana. He was 7/8 white. When someone says you're 7/8 white, what it means is this, is that every human being, I haven't quite figured this out, I'm quite certain just about every human being, it's possible with inbreeding and so on that this is not true, but every human being has 8 distinct great-grandparents. And so to say that someone is 7/8 white means that 7 of the 8 great-grandparents that this person had were white, and one of them was black. So Homer Plessy was probably no darker than I am. Nevertheless, he never sought to conceal the fact that he was black. In 1892, or that he had black blood. This is the craziness that our society perpetuates. If you have 1/8 of your heritage as black, that means you're black. The state of Louisiana in the year 1892 passed a law on the operation of railroads within the state. And railroad law said this, that if you were a black person, you had to ride in the black car. If you were a white person, you had to ride in the white car. And Plessy made a conscious decision to challenge this law. Remember, he could easily have passed, had he chosen to pass, had he wanted to ride in the white car, and the white car had superior facilities. If he wanted to ride in the white car, he undoubtedly could have gotten away with doing that without a problem. But he announced himself as being, by definition in the state of Louisiana, black, and he was arrested and thrown off the train. And the case made its way up to the Supreme Court. In the Supreme Court, Plessy argued that, in fact, here's an instance where the state is passing legislation that's directly discriminatory. Back in the civil rights cases of 1883, the reason that the Civil Rights Act of 1866 was nullified was because why? It was because this was not the legislation of the state, but the action of a private business owner that was in question. But in 1892, with the passage of this act in Louisiana, it's the state that is acting in a discriminatory fashion. The defendants in this case, the state of Louisiana, answered back in this way. They said that just as black people were barred by this law from riding in a white railroad car, so white people were barred by this same law from riding in a black railroad car. There was no discrimination. That's the argument that they made. That there were separate but equal facilities. The equal, of course, was a fiction, but the separate was real. Black people were barred from riding in, black people were barred from riding in white cars, white people were barred from riding in black cars. And the Supreme Court, again, in an 8-1 decision, again, the same justice who protested in the case of the civil rights cases of 1883, protested in the Plessy versus Ferguson decision. The Supreme Court established on an 8-1 vote the legal basis for the South passing discriminatory legislation, so long as the fiction of separate but equal could be maintained, so long as black people were barred from a white bathroom and white people were barred from a black bathroom, there was no discrimination. It was all equal. And so separate but equal becomes the mechanism by which legal forms of segregation could be instituted in the South. Harlan said this, Justice John Marshall Harlan, everyone knows that the statute in question, the Louisiana Railroad law, had its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks, as to exclude colored people from coaches occupied or assigned to white persons. In a legal sense, in legal doctrine and so on and so forth, the effort is always made to isolate a law from the social circumstances which surround it. And Justice John Marshall Harlan here says, this isn't going to cut it. You can say that white people are barred from black railroad cars, but the purpose of the law was to bar black people from white railroad cars, not white people from black railroad cars. Justice John Marshall Harlan, again, in his dissent to the Plessy versus Ferguson decision. State enactments regulating enjoyment of civil rights upon the basis of race and cunningly devised to defeat legitimate results of the war, meaning the Civil War, under the pretense of recognizing equality of rights, can have no other result than to render permanent peace impossible and to keep alive a conflict of races, the continuance of which must do harm to all concerned. So he's saying as a result of the passage of this Plessy versus Ferguson decision, rendering of this Plessy versus Ferguson decision, the Supreme Court is condemning the South to ongoing racial warfare and racial conflict. We boast of the freedom enjoyed by our people above all other peoples, but it is difficult to reconcile that boast with the state of the law which, practically, puts the brand of servitude and degradation upon a large class of our fellow citizens. So Justice Harlan here says quite clearly, and this is the history of the United States in a certain respect, summed up in a single sentence. We boast of our freedoms. We boast of the great liberty achieved by the American Revolution. And yet the reality is that even as that revolution was being won, there were, I think at the time, 700,000, 800,000 people in chains. And so now continuing in the post-slavery period, in the post-Civil War period, it is difficult to reconcile that boast with the state of the law, which practically puts the brand of servitude and degradation upon a large class of our fellow citizens. The purpose of these laws is not to separate, it is to humiliate, it is to degrade, it is to say that the only position that black people in this society can play is one of servitude. The thin disguise of equal accommodations for passengers in railroad coaches will not mislead anyone nor atone for the wrong this day done. I'm going to quickly finish up here. I will say this, that when I was talking about Reconstruction, I described what I called the trajectory of Reconstruction. The trajectory based on the fact that when the moderate Republicans passed the legislation, the 14th Amendment, Civil Rights Act of 1866, and when Congress took control over Reconstruction out of the hands of Andrew Johnson, they did so not because they were morally committed to black people's rights. They did so because they knew and they wanted black people to serve in their effort to prevent the return of the unrepentant white Southern ruling elite. If you had a hard time understanding what I just said, roll the tape back. Listen to that one again. I can't repeat it. And what I said at the time when I was talking about Reconstruction was that the problem with this pragmatic decision to give rights to black people, the problem with the pragmatic decision, a decision based on what my needs are and not what black people's needs are, is that so soon as my needs are met, I can turn my back on black people. I can turn my back on black rights. And that's what happens with the Supreme Court as of 1883 and 1896. The white elite of the North are now secure in their power, and they no longer need the help of black people to keep the white Southern elite in its place. The Supreme Court decision is reflected, or the thinking behind the Supreme Court decision is reflected throughout the elite classes of the North and their academic spokesmen. So here are a couple of historians writing in the 1890s. Again, what we're seeing here is the turnabout, or the return to a position of white supremacy on the part of these northern white academics. The claim that there is nothing in the color of the skin from the point of view of political ethics is a great sophism. A black skin means membership in a race of men which has never of itself succeeded to reason, has never therefore created any civilization of any kind. It's a standard trope. It's a standard trope of white racial thinking. It's a lie, but this is the kind of thing that white Americans in the North, in this period where segregation is being established, what these white Americans in the North are saying out loud to themselves. What the whole country has only learned through years of costly and bitter experience was known to this leader of scientific thought. You know what? I don't know who this is talking about. I'm going to keep on moving. Here's a New York Times editorial. Again, what we're talking about here is justifying the white South. This is the New York Times, leading northern newspaper, justifying the disenfranchisement or the taking away of the right to vote in various states, southern states, the black people's right to vote in various southern states. This is what I wanted to get across. I'm going to continue to talk about the role of the North in terms of establishing and implementing the kind of segregation that plays out in the South in my next lecture, which you can just click on immediately after you're done watching this one. Thank you.